Thank you all for attending this seminar. I heard Tom Standish and Judge Hoskin speak at the Ely Judges Seminar and also to the Family Law Bar. And I thought that the documents that Tom's come up with and the check approves of, both of them, will help in settlement negotiations, and if you have to do trials, will really help in trials also. So what I'd like to do first is go around the room and have everybody introduce themselves, and then we'll go to the faraway people. Valerie, you want to start?
Valerie Vegas, Senior Judge.
Jack Ames. Steve Kosach.
Kathy Hardcastle.
Nancy Becker. Chuck Hoskin.
Tom Standish. Michael Cherry.
Gloria O'Malley.
Chuck Thompson.
Eileen Spohr. I'm leaving.
James Bixler.
And who do we have in Reno? Deb?
Deborah Augusti.
Scott Jordan. John Arrows.
That's all.
And in Carson?
Bill Maddox.
Okay. Let me turn this over to Tom and Chuck.
Well, I'll start since Judge Hoskin told me he wasn't supposed to say anything at all during this entire thing, or made me promise he wouldn't have to. We have 3 forms that were sent out for your consideration. The first is the orange color form that is a marital balance sheet, and the other 2 forms are really the same form, just showing different ways to use it, entitled Reasonable and Necessary Expenses. The forms and the presentation of these forms in Ely and at 2 other groups arose out of discussions that were had between bench and bar and myself and the judges, where the prevailing theme was that the judges were not getting the information they needed from counsel to make decisions that they needed to make at the trial level.
I wonder if it's actually on this.
Since senior judges are hearing so many different types of matters, including trials and including settlement conferences, I think all of us felt that perhaps this was something that we should talk about much more, and the use of these forms much more, and how they might be implemented to help sitting judges, senior judges, or in whatever role you might be undertaking. So the first form is a marital balance sheet. It's this particular form was adopted by the Supreme Court. It's not mandatory for use in all trials, but it is under 16.2. It's very simply what it appears to be. It's a listing of the assets of the marital estate, and as well as the separate estates of each parties, broken down into asset categories. This form is an Excel-based form, so it can be emailed to counsel or emailed to the judges who may wish it to be used, and that means that it will tally up the numbers in whatever fashion you program it to do under the Excel program. What I have said to the attorneys when we've lectured is that this form is absolutely the best tool you could have for organizing assets and debts, no matter whether the case is a simple case with very few assets or a complex case that has hundreds of assets. And what it forces the attorneys to do, and therefore for your advantage as the judicial officers, is it forces them to actually write down the assets and the debts, or to get that information from their clients. And each category has, as you can see, the columns that run vertically that show the gross value and the debt, and a net value next to that, and then for division between the husband and wife, which we will probably, that's a little outmoded now, but maybe it's partner number 1, partner number 2. It shows the community value of the property that is going to that person, and then a separate value if there is a separate value to that asset, so you can see the total value of the asset being distributed across the board. There are a number of rules or tips or ways in which you can use this form that I think make it even more useful to the judicial officer, and we've been over this now with the General Assembly at Ely, which was some 350 lawyers or more. We had a paralegal track in Ely where these forms were presented, so the paralegals, and it was quite well attended. We spoke at the bench bar last week here in Clark County, trying to get lawyers who are not trained, who are young, or are just not using these forms to use them. The reason being that if they are used in an effective manner, it makes the judge's job hugely easier. Yes?
Are these forms that are on the website? Or are these your forms?
That's a good question. This is a form that I've been using for a long time, the marital balance sheet. It was developed out of really northern Nevada. A lot of us have been using this form for a long time. Gary Silverman and Susan Brackney in Reno really developed it. Other people have had similar forms down south that we've been using for a long time. They are, I don't know if they're posted on any county or state websites. Marshall Willick has it posted on his website, and they're available in various places. But we're going to try to standardize that, obviously, or at least not me, but those powers that
They're
be.
available to us.
Yes. And we can do it out of my office or off the Marshall Willick website. All you have to do is request it, and I'll send you whatever you want. We have one person in our office who's very adept at the Excel program, so as you'll see in a minute, if you wish it to be in a different format, we could do that for you. We can recreate the form, or if you have somebody at your disposal that can do that, then you can redo it.
And I have all these forms. If you want copies of them, I'm happy to forward them to you.
In Excel?
Yes. Blank forms, not filled out.
Yeah.
Great.
So, just in looking at this form at face value, this Larson versus Larson was the sort of mock trial, mock case that was used at the Ely Family Law Conference, and that's why those names appear. There was a fact pattern and so forth that went with all the different trial prep lectures that were given in Ely to the lawyers at the Family Law Convention. For your use, and I'm going to assume at this point that either you are hearing a trial as a judge or you are hearing a settlement conference. What I emphasize to everybody that I think is obvious, but it's not obvious to the lawyers that work in these cases all the time, I've found, is that there are certain things you have to do with these forms or else it's almost a gibberish to the court and it takes you longer to sort out what you're getting than to actually be able to use the information. The first thing is you have to absolutely command the attorneys to do the following. They have to have the same line item numbers for the same assets. So in this Larson example, the Bank of America personal checking account, these numbers are not in numerical order. They could be on a regular balance sheet. This was to demonstrate to counsel that you can run your entire trial off of this, labeling these line items with your exhibit numbers. And here, 5 for the plaintiff, E for the defendant, so that you have exhibit numbers there. In its normal form, you could just have counsel for a settlement conference just number the assets, 1, 2, 3, 4, 5. Some format. I mean, I never use up.
Excuse me,
all the numbers
could we
in one.
interrupt just for a second? Out of Reno, we are not getting a visual on you at all. We see Bill Maddox in Carson City, but we don't see the presenter in Las Vegas. It's not, the IT gentleman's here and he recommended we tell you because he thinks the problem may be at that end.
We're looking into it.
I was just in contact with Las Vegas IT, so they should be dialing in soon.
Okay. So we will proceed.
You guys want me to hang out for a bit just to...
If you don't mind.
You're still live on the mic there. I don't know.
So when I say the same line items, I mean that when you have the real property and the marital residence, here it's Exhibit 12 or L, that would always be, number 10, no matter what. And for the attorneys, it's smart to leave extra numbers in every category, so if you discover an extra asset or two, you aren't renumbering everything. The second thing is to have the counsel, force the counsel to standardize and sync the descriptions of the assets. I mean, all of you have had, I certainly have had as trial counsel at trial, I have the Bank of America Merrill Lynch something statement, and they have the something something IRA. It's the same statement, and they go to introduce the exhibit, and you're like, what is that? Oh, that's what I have down here. Two completely different descriptions of the same document. It's so confusing. It's so unnecessary. Just tell them if it's an account that's the joint checking account at Bank of America, I want you both to have joint checking account at Bank of America. I mean, that makes it so much easier. I know these things may sound sort of trite almost, but I'm telling you, they're powerfully important to be able to make you, the judicial officer, be able to look at this, one look, you've got it all here, and you can deal with it. So descriptions being the same, the numbering being the same. Also, you'll see that you have to make sure that if there is a debt that is reflected in the debt column, we do not do the marital balance sheet like CPAs do their financial statements where they list no debts with the assets whatsoever, and they list them all at the end. And I still have counsel to do that. And you're picking through the debts at the end like, okay, wait, this is probably the house loan. This is probably one of the car. You have no idea what the debts are. So you list them here with the asset. Mortgages go with real property. Lord knows we can't separate out the mortgage. You give it to one person and the real property to the other. I mean, again, I know I'm being overly simplistic, but you have no idea. Let's see, when we talked about civility, I said the lawyers were 7-year-olds, right? Here I said they were 12-year-olds. You have to treat them as 12-year-olds, but they're 12-year-old boys. They're really rambunctious, they don't pay attention, and they really don't listen to anything that you say. So if you don't organize them in this fashion, you're going to be really in for a waste of time, or you will simply never get the information. So those are two of the biggest things. Now, for a settlement conference, I would also expect that with the numbering on the left-hand side of the assets, that they would attach the document, such as the bank statement, and tab it, number 1, the joint checking account, the latest statement. The mortgage statement with the balance on it, attached as number 10, or maybe the deed also, or, whatever needs to be there. And if you do that, and you do it in an up-to-date fashion, and you have a packet, it's everything you would ever need as the judge to know exactly what the assets are and start dealing with how you would distribute them right off the bat instead of hearing all this ponderous, evidence to simply get together what the heck do these people have and what am I doing to divide it. So that is why out to the right-hand side you'll see some little dates printed out there. Very important. I try to explain to the attorneys, if you're trying to sync the documents, it doesn't really help the judge very much when you have a statement from March and he has a statement from September and you're at trial in, January. So it also tells the attorney, oh, I need to update this because this is really old. So that is another thing that is necessary to do. And by the way, I am compiling a checklist, and I'm sorry, I thought it was done actually, and it was sent out, but it was not. I'll do a checklist of all these things so that you can instruct attorneys if you choose to do them. After that, what we emphasized to the attorneys was that, for example, with an IRA account, it's very important. It's essential to know, is it a Roth IRA because that's a post-tax account? Is it a traditional IRA? That's a pre-tax account. I mean, you as the judge, I would think, would like to know that. What we also do, because we can do it with the Excel program, is we can take the retirement account category, especially where people have maybe a couple of IRAs or maybe a few retirement accounts, and we can isolate that out of the arithmetic on all the other assets so that the court can divide the retirement accounts just within themselves if they're all pre-tax.
Is this Siri?
We see you now.
The other things that I try to tell the attorneys that are sort of the last of the absolute essential things for this to help your judicial officer is you can see on this bank account list here on the Larson versus Larson sheet, they have an L or a J, which I told everybody was not very helpful, but those are the initials of the parties. I prefer like husband or wife or, partner number 1, partner number 2, or joint. In other words, whose account is it? I need to know if it's a joint account. It's particularly important on the credit cards. I just got a list of credit cards from another attorney, and these parties had a ton of credit cards. And it was absolutely incomprehensible because she didn't tell me are they joint cards, truly joint, or are they the husband or the wives? Because I don't know about judges, but certainly as attorneys, I want to keep my client's credit cards out of the hands of the other person to pay after the divorce if I can, so they won't ruin my client's credit if they don't pay it. So that's important. And I told the attorneys, too, how about giving the judge a break and putting, like, a husband or wife by the cars so they know who drives them? It's kind of important, too, so they know what payment goes with what. So those are little tips, but they're actually really, really important. And if you have the counsel doing all of those things, then you will get a package for a trial or for a settlement conference that, from my view as a trial lawyer, is really going to make your job a lot faster. We've had a couple of judges already where we're starting to tell these stories to attorneys now, where the judge called counsel into chambers and said, I don't need to hear anything at this trial. It's all here. We just have to argue over this or that, but I don't need to have evidence on all this. Because once you make them sync the descriptions and you make them sync the timing of the statements, what do they have to argue over? Otherwise, of course, you always had it, ad nauseum, they argue over things that they shouldn't be arguing over just because they have different information, different dates, different amounts. I mean, it's ridiculous. So another thing that, say, Bob Dickerson, I know, does a lot when I have these charts with him is he runs a husband's value, wife's value columns side by side. That doesn't make it add up really well on the Excel sheet, but if you wanted that, if they were at odds over the values of various things, maybe you had several properties and they were arguing over all those values, you can run those side by side. It's easy to put in another column and show the differences between the attorneys as to what they're saying, the two parties, what they're saying are the net values of assets. If you have, we have statistics that I've been told around 70% in Clark County Family Court of pro-per versus pro-per cases and pro-per versus attorney cases. Those altogether are about 70% of the caseload. I don't know what percentage of the 70% is attorney pro-per cases, but my point is where you have attorney and attorney, you should not have to spend all of your time, waste all of your precious time and your concentration trying to figure out what the heck people have. This should do it. And the attorney should be forced, I'm saying, I've said it to the judges in Ely, I said it to the lawyers in Ely, I've said it to the bench bar here, they should be forced to do this. This is the only way to run a case. For the inexperienced young attorneys or experienced, not knowledgeable attorneys, if they're introduced to this and made to do it, it makes them better lawyers, and once again, that long-term will be a benefit to the bench. But right now, the focus of this is just to say, this is what you need, you should tell the attorneys to do it so you get it. I know that sounds, once again, like I'm being overbearing. I am a trial lawyer, I've never been a judge. I can tell you I've done a lot of mediation, though, as a mediator, and in simple cases and complex cases, and I sympathize with your plight. I don't know if other mediators do this, I don't hold a mediation now, ever, without a phone call with the attorneys, and then usually a meeting. And I've been actually a little surprised with experienced counsel, like, well, do you have an appraisal for the house? No, we haven't done that yet. Have you, done this? They're not ready at all. They're not ready. So I organize them, I get them going, I do a marital balance sheet if they're too late to do it, and then I mediate the case over what's actually in dispute rather than taking, as I have in some larger mediations, 2 full days I've done to finish discovery because I can't interpret what they're mediating. I don't have values. So again, the simplest of cases will be simple if you have this information, not if you don't. They can be, as you know, very vexing because you just can't figure it out. Complex cases, obviously organized better over this too. So we're on a mission, my partner Jason Emmy and I are on a mission to organize counsel before mediation. I don't know why, the judges would not, the attorneys would understand the judges want them to be organized before a trial.
Would you advise the judges who are doing pro-per settlement conferences to sit down with the parties and try to do your sheet?
If we don't,
at the mediation?
It would probably be the fastest way to do it. But if you have one attorney and one pro-per, I'm just saying leaning on, I'm sorry to be so harsh, but leaning on that one attorney to produce to you this marital balance sheet with the proper documents attached and tabbed, come on. That's that attorney's job. They need to do it. And if there are 2 attorneys, then instead of getting 2 different marital balance sheets, you need to get one that has the same descriptions. By the way we learned this, the hard way, was we come to mediation. The last few times with Jim Jimerson, who's an incredible mediator, we come with a complex case, and we have all these assets, and we have 2 marital balance sheets, and it's really simple. We don't ever try to sync them. It's just too hard. We just abandon one of them. Somebody has to give theirs up, and we use the other person's. That's where you have counsel that you can trust. They've got a complete list of the assets. Maybe we double-check that. The point being, you can't use 2 separate marital balance sheets at one gathering, whether it's a trial or a mediation. It's just impossible. I mean, it's just impossible. You might have an extra asset somebody else doesn't have. They've described them differently. You have different statements at different times. I mean, it's just chaos. This is order. Normally, it's chaos.
Tom?
Yes.
I think, well, perhaps you don't know because your level of client is not always the same level as we see in the courtroom, frankly, most of the time. And most of the time, if that lawyer comes in, it's unbundled, and that's it. They're there for that one hearing and not. So I can see using this, just like Justice Cherry just said, you know what? This is what I want you guys to do. I want you to follow this sheet. Here's a blank one, and this is how I want you guys to go with it, because otherwise, you're right. This one introduces the same exhibit as that one, and why? Right? Don't you agree, Gloria?
Well, I can see you doing it privately, because you do have more time. When you're doing, like, for example, senior judge doing settlement conferences for a week, I can't take a half an hour to instruct the pro pers or even the attorney to get on the same page. That's the reason they're getting a divorce.
Well, we discussed sanctions in ELE with the judges that were there. I guess I'm just I was going to use a dirty word. I guess I'm just a jerk, okay? I think you could say, Mr. Standish, I'm here today, I won't be here tomorrow, but I'm telling you, the next time I'm sitting, if you come in with no marital balance sheet or this piece of junk, you're going to be sanctioned. And then you sanction me. You're not being reelected, so that was the big thing the judges told us, was we would rather not do that. So maybe, I don't want to terrorize the attorneys, but yes, you realize what's happened, right? I mean, we had a recession, and the bigger firms stopped hiring, and they're barely hiring now. There aren't a lot of jobs out there. Many, many more young attorneys are out in their own practices or with other young attorneys. So the training that has always happened in the big firms with those people coming out into private practice, which produced so many good lawyers, or people that were lucky enough like me to have somebody like Howard Ecker or Jim Jimerson to have trained other people he's trained and so forth, that's not happening very much. So this is training. You train them to do this, and if they never get it, that's fine, but at least they get the concept that you would like this information in this form, and actually you're going to get a little upset with them if they don't. If enough of the sitting judges start to do this, and if the senior judges follow suit, you might even create a situation where people know they have to do it. Now, that's a dream, of course, but I'm saying day by day, for you as judicial officers, you all have tremendous experience on the bench. I feel particularly embarrassed that you would have to sit in. You're doing an incredible service for all the lawyers and the litigants, and again, everybody's in debt to you whether they know it or not. To have to plow through all this stuff almost seems like abusive to me. At your level of experience and stature, to have to put up with that nonsense anymore. So that's why I'm saying some consistency using the same form, which the Supreme Court has already given the nod to. It just makes sense. But it's going to have to be at your consideration and your decision as to how or whether you want to do this.
Let me jump in for just a second,
yes.
So I can, along those lines, what we're doing, at least in the 8th, is the judges have essentially committed that this is going to be an attachment to our case management order, so that it'll be a requirement pre-trial, and then we get the sanctions with regard to that. And the other part of that is it's going to be part of the order. We're going to change over to when we refer to the senior judge settlement conferences, there'll be an order referring them with requirements in the order, this being one of them, showing up on time, all the things that you guys have complained to me about for years will be included in that order as well, with the threat of contempt coming back to the judge that
We're going to start seeing these.
Yes.
Good.
Yeah.
And we do, when we have a trial statement in family court, I see these as we were passing them out. I don't know about unbundled. I don't see anything at all from unbundled.
Well, and that's why we're putting
And that's a big problem.
Well, I know
That's a big problem.
the example that I've given in that area is Judge Sandra Pomerantz is very consistent in her courtroom at the end of an unbundled case. If you withdraw and you have not either prepared the order or signed off on the order, you get a sizable sanction from her. I mean sizable, because she obviously, I think, I'm not speaking for her, but I mean, she can't do business that way. I mean, people come in and out and nothing gets done, and either her department has to do the order. So I'm sort of suggesting, I guess, to the attorneys, I made no bones about it anywhere I've spoken, that that's going to start to happen on the front end. Not maybe the sanctions, but the idea that you're going to be required as an unbundled to come to court with this, and if you can't get this done, then I don't know what's going to happen. Maybe you just won't have a hearing that day, and you're going to have to come back, and it's going to cost your client more money. I don't know how the judges will handle that. But unbundled is a problem, and
Is it worse than proper person, you think?
in some ways, yes, because they're there, and you can't ask questions directly, and they're ignorant. I mean, Judge,
And they don't care. They don't care. I'm out of here.
understand that
I'm out of here.
this form is part of the, Tom Standish view of doing family law cases anyway, which is anytime I force the other side as an attorney or the judge forces the other side to get together and talk about what the issues are, you see an amazing success rate for settlement. That's what formal private mediation that we do, especially in our complex cases, has been shockingly successful. I mean, impossible cases to settle, constantly settle in our private mediations, and those are complex cases. But as you know, and I by the way, just remember, I have many small cases. And in our office, because we have a lot of young attorneys, we do all kinds of things, and really organizing at any level is really critical.
Well, I agree with you, that wasn't the issue. The issue is, when they come in unbundled, they may have just met with the client that morning. So, but the point is that if we have a blank form like this, then we can sit there and use our time and say, okay, let's just go through the form.
That would work.
Because that's all you're going to do if you put your client on the stand and you start giving me documents and why don't we do it jointly so that at least we're using the time productively, the trial time.
Can we train the self-help people the people who need self-help on these documents?
Right. That was what I was about to say, was we in our informal discussions between bench and bar have dreamed in Clark County Family Court of one day Clark County hiring a triage master or several that would meet with the pro pers. I think that's coming, and I'm prepared to lobby the county commission anytime you want, one by one, to show them that in the administration of the courts, if you sat down with, and this is a pet sort of peeve of mine, is just because somebody doesn't have money doesn't mean they're not intelligent or capable of putting this together. And frankly, with the unbundled problem and some of the level of practice we've seen, probably you're better off getting this information directly from the people, because honestly, they know what their credit cards are, they know what their bank statements are, and they can probably find like a car title and a mortgage statement, and they can do this for the court. So yes, if self-help could tell them, oh yes, the judge will require you to have this information, maybe this form will actually start knocking down some of the 70% pro cases and put them in some form where you can deal with them, but that I don't know about. I'm not a judge, and I don't know what is planned there, but I can see the politics of it, and this being used by the attorneys first is the right way to start, and then maybe it can go system-wide at some point, depending on what the manpower is. So that's that chart. Let me move on to these other two that are green-colored charts. This is a chart of monthly expenses for each party. There are two of these. One of them that I'd like to start with just says, in the purplish gray part there, says Jonathan's FDF and Linda's FDF, and then Linda's R/N, which is reasonable and necessary. The other one has a bunch of columns. It has a condo expenses column, a business expenses column, an adult children expenses column. That's the one I put aside for the moment and just deal with this first one. The way in which the current financial disclosure form is set up, it serves a number of purposes for the court, and it is the court's official document. This is just Tom Standish's chart that I dreamed up. But I found it to be effective, and the presiding judge and others told me I should include this in my presentation to the judges and the lawyers. It's just a reordering of the expenses that would normally come on and a reorganization of the expenses that somebody would have, a typical person would have, or a couple would have on a monthly basis. But it's been reordered because the financial disclosure form, for sanity's purposes, I assume, alphabetically lists the categories expenses, and I personally cannot do that. I mean, I need to know rent and mortgage payment and lease like up front. It just seems to me, I don't know, it's just me, okay, but I had to have that first. And this entire first page is what is called non-discretionary. It's at the top of the categories of expenses. And what the point of this is to say, look, litigants rarely argue over how much the mortgage, the property taxes, the insurance, and the utilities cost on a monthly basis. Yeah, you could say, oh, that's too high, and she doesn't really spend that much on gas or electricity. But, I mean, those are things on a bill that if you had to, you'd collect 12 bills and you could average them and know what it is per month on the average. Same with, you know, basically cellular telephone. I struggled with whether gasoline would be discretionary or non-discretionary. I mean, you can put it in either column. The point is, these are vastly things with kind of name on check or name on bill type of expenses where your insurance doesn't really change that much on a monthly or yearly basis, for that matter, and so forth. Also, on this list at the very bottom, you can see minimum credit card payments. I mean, those aren't discretionary. You have to make the minimum payment. So that's why they're on this. The second page, just in generalities, is all the things that are somewhat discretionary. I mean, certainly housekeeping is discretionary. It's not discretionary for too many people. They simply can't afford it. But I mean, food, groceries, dining out, travel, clothing, special activities, all of those things, personal care, those are very discretionary. And so the original idea, the reason I got to this was I found that if I can get this first part done, this page, I have a pretty good idea of what are the sort of essential expenses and get reasonable figures for them. Then I leave for the second page the things that are the most likely to be argued over. And the idea is, in this case, I treated this as if I represented Jonathan. Notice his list of figures are first, and I run the other party's FDF numbers next to it. It causes me to do two things. Number one, it lets me see, you know, what I think Linda's expenses should be, and when I disagree, I put a figure over in this column. I don't put a figure in the Linda RN, reasonable and necessary. When I'm saying Linda should have this reasonable and necessary, the opposing party, I only put a figure there when I disagree, and I think it should be less. On this one, we showed that Linda was deficient in her FDF, so I had to give her expenses. I had to do the right thing and say, you know what? She is going to have health insurance after the marriage. I got to put that in there. So there are red and black figures showing where I deducted from what I thought she had. It was too high, and when I had to add something in because I thought she was too low. So that category, though, generally on the second page is what they argue over. For the judicial officer, what it does is it distills down all of these expenses to 5 or 6 or 7 things that the parties are arguing over. And that's generally the case. I tell my clients all the time, here's the big secret. Nobody wants you to know about alimony cases. On the expense side and the need side, they come down to like 5 or 6 categories, sometimes less. That's everything on here. Not only that, it adds it up. This is an Excel-based document. It adds up the categories for you, the judge, so you can see, oh, Linda's claiming she needs $8,900, but the husband's claiming, you know, she needs, you know, $7,800. And it does it all for you right there. You can also have the children's expenses run separately so you can see the categories. It's a little bit easier than just the way they have it in the FDF. This document we've used a number of times. Actually, we had a special needs case. Judge Hoskin was the judge. The other side was great, and they agreed just to go to Judge Hoskin and say, look, here's our chart, and we're arguing over alimony. Just tell us what you think you would do. And I think this made it easy for him to see what he wanted to do. He saw where we were disagreeing on numbers, and he only had to look at 5 or 6 numbers to see what he thought they should be. And that was it. So the idea of, here it is, oh, by the way, it forces the attorneys, sorry, I forgot to say, for me personally, it makes me look at what I have for Jonathan for, like, clothing, and then I look to see what Linda put down for clothing, and before I argue she should have a lot less, I look at my own guy's thing and say, oh, wait a minute, he has more than that for it. It also keeps the attorney from embarrassing themselves in court, but it definitely shows you, as the attorney and definitely as the judge, where the parties are relatively, like, she's got this for, and granted, for example, women would tend, I would say, to have more expense in personal care on the second page. I mean, they just usually do. That's fine, and the judge can see that. And people argue over that a lot. So this, they didn't have a lot of money, so neither of them were spending a lot on that. But nevertheless, the point is, I think you can get to the real disputes very quickly on this. The other thing that I encourage the attorneys to do, and really, really, really encourage them in this simple chart to do, is say on the comments line out to the right why you don't like it. Cell phone is like the best example, is paid through his business. You just put that there, and the judge knows what you're saying. Or, we don't have that bill anymore. That credit card was paid off 5 years ago. I mean, again, you look at the numbers, you look at the explanation why they don't like them, and as the judge, I mean, my partner actually had a case just a little while ago where they were doing alimony, and the judge called them into chambers and said, I have your chart. I don't need to hear any testimony unless there's something else I need to know. It's all here. I know exactly why you don't like these numbers. It's cryptic, but I get it. And both attorneys were able to say, yeah, I guess we don't really have too much more to say. So that is what we're talking about by using this chart. If you make the attorneys do this, I could save you tremendous time, I would think, in testimony. Because I don't think attorneys quite understand the usefulness of a chart like this, especially on motion calendar, where I know as a young attorney, I went in and I didn't even know how much to ask for my client. I just figured the judge would make a ruling. I mean, sorry, but I remember doing business that way. A little horrified by it today, but I'm just telling you, if I had done this chart, I wouldn't have had to ask the judge anything. I would have had to look at the totals, realize how unrealistic it was to say that the other side should have X dollars. It's a great client tool to say, oh, you think he, she shouldn't have this much to spend? Okay, look at this and tell me where you think it's too high. It kind of adds up.
What do you do about findings in either of the charts that you presented today? How do we, like, if we're going to review it, how do we review it? Just on the decree itself, or help me?
You mean as an evidentiary question? Because
Findings. We're pushing for everybody to do findings and conclusions of law, I assume. So,
well, I think you could have a person adopt this in their testimony in about 30 seconds.
okay.
Or say, did anything, is this your list of expenses? Yes. Has anything changed? Yes, I have 2 changes. Now you're done. Again, judicial efficiency, I mean, it's hugely
Well, especially
great.
for these folks, there's no reason for
But
that for long.
in terms of efficiency of seeing what they're arguing over and then making a decision, I mean, this actually, I know I'm saying anybody could have made up this chart. It's not unique. But when we've actually put it into use, it's been great. Yes, Judge Bishop.
Not having experienced this, I'm a little baffled on how this comes into play. You've got the attorneys there, and you say, here's the form. You're going to have to fill it out. The 2 of you get together, fill it out, each of you, we're only going to use 1 form. So both of you get together, fill it out. Is that how it works?
Well, they have to file an FDF by the rules. So it's on file whether it's attached to the motion or whatever. If you're this is great this is more of a settlement tool perhaps than a trial tool. But if you force everybody including that unbundled attorney, to simply take the figures off the FDFs, which anybody can do. Their secretary, their paralegal can do it, isn't a lot of attorney time, and just run them next to each other so you don't have to do it, then you've got half the battle. And tell them, if you don't, and then run the reasonable and necessary column for the other party. What do you think is reasonable? And why is it not reasonable? In the comments, you would have so much more, you'd be so further down the road. So again, for motion calendar, I could see a time if the judges liked this forum and liked working with it, where they would tell everybody, don't come into court without it. Now, this is a little bit of an awkward situation. This is more or less a private meeting, so I appreciate if you don't quote me on this, but the financial disclosure form in its present form is really hard to work with. And I know that a lot of hard work went into that form by a few attorneys, and I really appreciate all the time they spent on it, but I'm not sure that it's that user-friendly for me as the opposing attorney or for the judges. So this is just me saying this is a different way to express a portion of the information that is on the FDF form in a way in which it cuts through the arguments and it shows you exactly what they're arguing over on these particular types of issues.
What I've been doing, Justice Cherry, to kind of answer your question, I've been doing this on my own if I've got an alimony question. And I pull them myself from the FDF. So they're part of the FDF. They're already in the record that way. So I guess as far as a finding is concerned, the finding would be based upon the information obtained.
I was thinking if it's a settlement, then it's unlikely we're going to ever see it, hopefully.
Well, and that's the bottom line, and I've mentioned this, I think, every time Tom and I have talked about this. I don't get a lot of these because if the attorneys are doing these, they never make it all the way to me. They're done before they get to me. So it plays in a lot with the attorneys, but from a judicial standpoint, at least the way that I'm looking at it, I have to take that step and require that they're actually utilizing them. Because if they do utilize them, they're able to take a look at it, most of them are reasonable, and the case resolves.
And that was brought up in general session of me pitching to the attorneys very carefully saying the marital balance sheet works in the simplest of cases. You owe it to yourself to use it. And on this form to say to them, with these two forms alone, think about calling up the other attorney and having a settlement discussion on the phone. It would be very productive, whereas normally you're in two different places and you don't even know if you agree on anything. If you get together with the parties and the attorneys, it makes you look good in front of your client and you have a more productive discussion. If you're having a settlement conference with a judge, if you're having a senior judge settlement conference, if you're having a formal private mediation, or if you're going to trial, and trying to show them that at every stage of the litigation process, if you can focus on the issues and organize them, you'll probably get a settlement. And yet today we see a lot of cases going to motion calendar in particular and to trials in general where they're not organized. And again, that can be because they're too busy to do it. They don't realize the value of when you put a few minutes into this forum, you've saved yourself hours and hours of time and you're a better lawyer, but we're trying to get that message out. Now, the second chart is just to demonstrate, this came out of a case that I actually had, where on the FDF, they were expressing, we had the husband and the wife, and then they had a condominium that was kind of expensive. This was a professional, so they had a little bit of dough. And it was in a separate, outside of Nevada, and they weren't renting it, and he had to pay for it. So we had expenses for that. He had a separate business, separate from his professional job, that was like a side business. So it had all of the expenses of a small business, and he had 2 adult children that they were paying certain things for. And so when we came into the case after it had been all worked up by the 2 attorneys, and they'd been to 2 motion hearings, and the judge kept continuing things because it was obvious to us she couldn't understand what the heck was going on with the numbers. When we broke it down into columns like this, it was crystal clear where all the money was going, what those expenses were, and how much sense or lack of sense it all made. But off of the FDF, incomprehensible. I could not understand what my client was telling me. He had different accounts for these things too, and it was still, meaning the FDF is not really set up or equipped to deal with a couple of extra columns of expenses, but I'll tell you, a lot of people have them. Maybe they have a rental house. How many times have I seen I can't understand it. Like, we had a case where I couldn't understand whether the association fees were high for one house or whether she was including her rental house in them. It was just, you couldn't tell. Whereas here, it would be crystal clear exactly what was what. So I just give that to you as an example of this, believe me, for monthly expenses and alimony, this was a complex case. But it was simple once we did this chart. Really simple. Once we saw the stream of expenses in each column, it was obvious where we were headed. For example, it showed me right away that they couldn't afford the condominium, and unless they could sell it or one party could take it over, it was simply unapproachable by my client to afford it anymore. But that I couldn't get that really before because I wasn't really sure what those expenses were. And I'm just saying, as a practical matter, when you think this through, as again speaking to you, the seniors, as a judge on the bench, this would be very helpful to organize if you have one extra category of expenses. And a lot of people have children in college, and I realize that those expenses fall, secondary, since they're maybe adults at that point. But where in special needs cases, you absolutely have to run these columns because you have all kinds of special expenses that don't fit cell phone and food and all that. We run all the different therapists that people have when they have autistic children, and we run these columns, and it's so helpful to see where the money is going and what we need to do with it. So again, I recommend the chart here for that purpose as well if you have confusion over some extra category of expenses. I said you didn't have to talk, but now you have to.
Do I? Does it make sense? Does this stuff make sense? Is it something that you think can be utilized by the seniors, either in court or senior settlement? And if not, what can we do different before we implement the requirements? What can we do different to make it better?
Well, it does make sense. And it makes sense in a lot of ways where once we get, and I'll read them in the morning or before I get in. Glance at them. The briefs, I'll read them maybe at night, but I don't curl up with them. Okay, and I always told lawyers that. But if you can get the form out to the lawyers to include them with their trial statement or their settlement statement, great. Because it helps you in a couple of ways, like an alimony case. The second chart, the second chart, for example, would be an alimony case, wife unemployed. You see what I mean? Just your eyes track in addition to what is being spent monthly or yearly. So that helps in that way.
Now, I'm just saying to all of you on this, up north or in the south, as a practical matter, there aren't that many senior judges that are sitting in family court. If you call my office and say, Tom, I need to redo the chart so I can use it the way I want to use it, just tell me. We can redo it for you and email it to you. It'll be in Excel as long as you have that program, and you can use it. I'm willing to do that. We can field calls. Haunani in my office, who's the paralegal whoever, two paralegals, she lectured to the paralegal track in Ely. By the way, the paralegals were far more enthusiastic about this than the attorneys. The attorneys don't want to bother with anything, right? But the paralegals were really happy. They wanted something good, and they thought, any form is great. So they were, a much more receptive audience.
Tom, we could, Chuck can send it to Eileen, and then Eileen can send it out to all of us, so we're not all individually.
But I'm just saying, if you want something you want husband and wife next to each other with their value, you can call me. We can do that. That's very simple. We can send it back to you, and then you will save tons of time and money for your litigants.
And I personally, while I like this form, I like the husband alleges, wife alleges columns next to them, and then I can fill it in with a column that I ultimately find. But my form has it that way, and it's helpful to me but I don't know that it's helpful to everybody else. So that's a way of looking
But if
at it.
it's Excel, we can play with it.
That's exactly
Or-
right.
And for those of us who are not technological, we can get one of the others to help us.
Why is there not a column for husbands, fees form necessary?
Just that we did this from our point of view, we had one side of the case, but you would just reverse it if you had the other side. And they would tell you, the other person they think is reasonable.
You represent the husband, and the husband can't lie to him, so that's what it comes down to.
You know, even if I had a blank form like this, and I've got two pro pers, getting them to sit and agree and just telling them that, what's your mortgage, or your rent, or your lease, just tell me, right there, you know, what's, you know, and then being able to say to them, well, look, this is what you spend, this is what she spends, or partner one and partner two, why do you think
Right.
that this is inappropriate? Why should this person not spend the same amount
Right.
that you do? What's the factor besides you're pissed? Essentially, that kind of dialogue with pro pers is what gets you through your trials really quickly with them. It keeps them from getting more frustrated, because it's easier for them to do that than for us to be asking them more legalese kinds of questions that, you know, they don't know what we're saying.
I've told attorneys privately, they think I'm nuts, but I've told them, if you have a pro per on the other side, why don't you get one of those, like, sticky pieces of paper and put it on this list here and just tell the other person, tell me what your expenses are, and you can lift that off and put it next to your other guys'. I mean, just anything that works, but when you get them side by side, that's really, I agree that any time, like I'm telling the attorneys, look at them side by side and then tell me what it is, but you could just ask a pro per or pro pers that, and you would get the skinny.
As far as the practical aspect of using these type of forms, it can be hard to get this, but I've actually had a couple departments where I've covered for the law clerks are preparing these, similar type of list. And whenever I sit down and cover that department and I'm doing their hearings, I've got uniformity in the way the law clerk is doing it. It's easy to read and it's easy to make a decision. And it's easy to give consistent decisions. So
I've
the
been
law
using this
clerks-
for years, but I've been generating myself. So to have the attorneys send me an Excel spreadsheet that they've both looked at ahead of time, it would make my job so much simpler.
And if you've got attorneys there, that's great, but if you don't have attorneys, the law clerks can be the ones providing this for the settlement judges when we're going in, and then I can sit down with the parties, because I spend time with the parties going, okay, do you agree that this is your debts? Do you agree this is your expenses? Do you agree? Where's our disagreement? Okay, now we know what the issues are. The biggest issues are the alimony and the presumptive joint custody, because nobody wants to pay child support, and they're all going for joint custody to avoid that. But to handle the rest of it, it's not that hard to resolve.
And this will cut down a lot of what you're dealing with on the
It'll
alimony
it'll
side.
save me about 30 minutes to an hour in a settlement conference sometimes, but
And frankly, if you're a senior judge in a department that has a law clerk that's next to adequate, having something like this that you can analyze the FDS yourself, it's very, I never thought to create an Excel like this. I would find that very helpful in being able to do it. And, you know, I'm sitting in for another judge. I may not think your law clerk is the greatest thing since whenever, but it is what it is, and it's not my business to tell you that. So,
And a lot of them, since they tend to be younger than all of us here, a lot of them have Excel backgrounds because their digital generation taught them that. So much the better.
All this reminds you when Chuck came up with 16-1. It was the older attorneys that had a little more trouble dealing with 16-1. The young ones, once they knew about 16-1, they thought, okay, we'll follow it. What's so difficult about it? Me, I had a terrible time with 16. So much of a bad time, I decided to become a
I didn't
judge.
mention that I was the one that came.
well, you still get the blame.
But the other thing is that if the young attorneys
For 30 years, they've
are doing
been
this, it's going to help the bar at all. It's going to really help the bar. And I think, in case you don't know, there'll be over 100 new attorneys coming in. And when new attorneys come in, as Tom said, there's no jobs here. And I think you're going to find them doing three things: criminal law, personal injury, and family court. And so if we could make the family bar a good bar, even with the youngsters, I think we're all going to be better off. And then we'll be better off as a Supreme Court, even though the cases are going to go to the Court of Appeals.
And if enough more experienced attorneys start using these, almost all of the young attorneys will start using them too, because they'll just see, okay, this is just a better way to go, or I have to keep up with, so-and-so and do it. I mean, listen, we got to our marital balance sheets from working with other attorneys that did a better job than we did. So it's a process that if you can make some inroads now and make some progress, I think that it'll really make a difference. But when we have, I'd start out telling the attorneys at both of the talks that we gave, what do you think is happening here? You have a Supreme Court and now an intermediate court that are getting all of these buckets of information like a dog's breakfast mixed up, like just horrible. I tried to tell them, don't you think the Supreme Court has an interest in seeing a standardized formatting? Do you think there's a reason why they said for the general jurisdiction judges in the rural counties, they've got Todd Young formalizing everything and putting forms together, they're going to be consistent for all those judges? Don't you understand what's happening here? And I try to get them to see this is coming whether you like it or not, just to kind of brainwash them a little bit. But I talk much more to them about how, we have families and you never have enough time, and, if you use these forms, you owe it to yourself and you owe it to your clients. It's so much better, and the simplest case becomes simpler and the complex case becomes simpler. And I just know that getting them to focus on the case is the key, and they have too many cases. They have a lot of volume, most of the family attorneys especially, and they just aren't organized. Did you hear the Judge Ritchie story? Focusing on the case. When he came back in from a quarter caseload, from being the chief, he set a counter call, so to speak, a status check on every single one of his cases. He got 3/4 of his cases were now new to him. And he said that it was really remarkable and scary what happened. First of all, a huge portion of the cases settled because he set a status check, so they didn't have to come. But a lot of the people came and said, and he set the status check, they knew it was there, they came to court, and he's like, okay, Mr. Spanish, now, what's this? Well, Your Honor, I represent the Mrs. Smith, and they have 2 children that had no idea what their case was. So if that's the situation, then you really do have to force that attorney to come to court with the information, because otherwise it's hopeless. And if he or she is that hopeless, then maybe the other attorney will come with this form. And again, if it's a settlement conference for a senior judge or a motion calendar, that's why I think that we're headed that way, is that you, the judiciary, are just not going to be able to put up with it anymore, and you won't have the time.
What about in the eighth, forcing the judges, give them more time to give the lawyers more time to prepare these forms? In other words, the way you assign them, how much time does the lawyer have to give a settlement statement? How much time does the department have to give us the information?
Well, the deadlines are set by 16.2 or 16.205, so it's not a matter of when we're setting them. I can tell you that at my case management conferences, I ask them, how much time do you need in this case for discovery? And then my trial is set based upon that fact. So, at least in my department, the attorneys are driving how much time they need, because their clients are screaming, I need to be done yesterday, and they're saying, I need to be prepared, and somewhere in the middle is where they get that, and then my case management order generates all of their deadlines based on 16.2 or 16.2.
Eileen, how are you assigning settlement conferences with the senior judges in the 8th now? How is that happening?
Family court?
Yes.
I'm trying to do it so we take turns, giving everyone who wants to do it the opportunity. And I'm working with schedules with, vacation times as well. As it turns out, Steve just switched with McGee because it was easier for him for this week. So I'm working with everybody on their schedules, but I want to make sure if anyone wants to do it, they have the opportunity to be there.
But how does somebody get into the settlement situation with the senior judges?
That's done by family court.
Yeah, that is
That's
set
done
up
by
ahead of
family
time.
court, and they have a rotating, everybody gets a day
to set whatever.
Rotates, everybody gets,
And then what happens is,
So that's what I meant about timing.
if somebody
In other-
doesn't fill the slot,
Yeah.
then it becomes open, and then my JEA goes out to everybody and says, do you have one to move in? Or if she's got 8 or 10 on a waiting list that she fills in
But
based on
it's usually
schedules.
at least a month in advance that they know about it.
Oh, or more, yes.
Yeah.
Yeah.
So they'll have, I mean, every once
should
in a
have
while
that
they'll
time.
fill in, but
And
usually
there are
those orders
some
go out.
times where they'll call me and say, I couldn't get in the regular course, can you get me in anyway? And I'll bring them downtown and we'll do it in our
How
office.
does
the
Deborah
problem
deal
is
with
the
North?
lawyers wait, if they have 60 days to do it, it's the 54th, their 55th day before they start looking at it. That's the problem.
Or first.
Or even look at which is why we need that order in place.
Settlement.
It's not unusual. I get briefed 50% of the time, right?
Well, we're working on
Fix
brief deal. Did you get your order out?
Not yet.
Okay.
We're
We're working on an order.
One step at a
Finalize
time,
this
then.
part of it.
But he's going to have a very strong order that'll be very favorable to the senior judges.
Law clerk was-
Eileen, what about Deb up north? How does she,
Well, I'm-
do we have any idea how she
I'm
does
sure, but
the
I wanna put
assignments,
that on
the
the
settlements?
Because
I don't know.
There's no, I do not.
I don't
believe-
even know if there's a
We can
program.
ask
Respond.
Deborah, Auguste, or John, or
Is Scott
Bill.
there?
but-
Yeah.
Scott, how are the assignments in the second?
Well, we do it, from what I understand, we do it completely differently up here. The only time that a senior is assigned in family court up here in the second is when one of the sitting judges is unavailable. So we don't have the special settlement track like you have down there in the 8th. And all the cases that we have up here, we're sitting in for a judge that's not available, so the cases are flowing along kind of in the usual course, as if they were going before the sitting judge rather than a senior.
Now, we had all the second district judges at our conference. Did you get a chance to talk to him about these forms?
No, but what Judge Robb, who co-presented with us, said was that in Reno, they spend a lot more time at the case conference on a number of issues, and she was very enthusiastic about these forms to aid the judges at the case management conference, because it would organize the information a lot better, make it more efficient, and they could dispose of a lot more of the issues, which they do everything from temporary orders to, trial issues at those conferences as they should. But it is much different up there, but the delivery of the information isn't any different, and the problem isn't any different, according to what she was saying.
This stuff too?
Yeah.
Tom, can I add one more thing? Tom, this is Scott up in Reno again. Can I add one more thing?
Yes, I was going to ask you what your take was on that in the second district.
Judging from the conversation down there today, one of the other things that we do differently up here, as we in our scheduling, we have a case management conference in every case, and it sounds like similar to what you do in the 8th. But the next step that we have is a settlement conference that's scheduled if the case doesn't settle at the case management. And it's not until the settlement conference and the unsuccess of the settlement conference that a trial date is set. So by doing it that way, we don't fill up the calendar with trials that don't go, which allows the settlement conferences to go a little sooner. And it also creates an expectation that we expect cases to get settled, because we don't even have a trial date until after that step in the process. And that was something that we got going several years ago under a process that was recommended by the National Center for State Courts. So I'm not sure if that's something that you might want to consider down there in the 8th. I know how busy all the judges are, but seems to work pretty well. Yeah, it works pretty well up here.
This is Steve.
Hi, Steve.
I was with you. Hi, Deborah. Hi. Settlement conferences are done by the judge assigned to the case, correct? Or do they move them around in the north?
Yeah, the normal is that they're done by the judge assigned to the case, but the lawyers have the right to opt out and ask for a different judge to do it if they choose. It doesn't happen very often.
But if the
Well,
senior's
yeah,
sitting
and
in,
that's
they
why
hear it just
it
to see
was asked
something.
down here. And Deborah, you'll remember whenever we did settlement conferences, I always felt like I was insulated by a jury, so I could do a settlement conference if I had a jury trial. But I always asked them, and so did you, I'm sure, Deborah, I always asked them, hey, do you really want me to do a settlement conference on a judge trial? And so that issue came up down here, so that's why I asked the question.
Well, let me just say that in the north, in the family court, where I have sat as a senior judge, the expectation and the norm really is much different from on the district court side of it, or the civil and criminal side. The expectation is that the judge who's going to hear the trial will do the settlement conference, and the culture is just different from on the other side of the street where the judge may have discomfort about urging settlement in a case where they're going to hear it as a bench trial. It seems to work very well. It's just part of the process. Scott's nodding.
Yeah, I agree.
I appeal to his higher authority.
I think, although it's called a case management conference in Clark, in all honesty, it isn't a case management conference because the judges are setting so many of them, they don't have the time to sit down with the lawyers and really discuss the issues. So it's essentially just how much time do you need for discovery if it's two lawyers on each side, or maybe a lawyer on one side. And with the pro pers, it's the judge attempting to say, now, if you want me to do something, these are the documents you have to bring me. Or the law now says that there's a preference to joint custody. And so if you don't want to do that, you've got to bring me evidence, and trying to do that. So it's used for that purpose. But 5-10 minutes, would you say, tops, for most of the cases?
How do you get around the rule? The rule is real specific as to everything that needs to be accomplished in a case management conference. And I know that in the north, they very particular that you get through everything. And I think that's why Scott mentioned that if the case doesn't settle at case management, then a settlement conference is set at the next one, because the very simple cases where there isn't a lot of property or debts, and the big issue might be child custody or whatever small issues exist out there, 5 times out of 10 it can settle at the case management conference. But it's not my experience that we can conclude those in about 5 or 10 minutes. More time goes into them, but you get more resolution out of a lot of them. And then those that don't settle at that point get set for the settlement conference down the road.
And I would agree with you, that's how it should work. But that isn't how it works, and I suspect in part it's simply because of the volume of the cases. It works better with the pro pers, because if you can spend a little time there, lots of times you can get them to settle right then at the case management conference, if they've thought about it and they understand. There's also, some of it gets delayed out through the automatic FMAC referrals, family mediation. And because the case management conference doesn't really occur until after that in most instances,
No, it's still early on. It's set as soon as the answer is filed in the CMCs.
Can I add one more thing from up north?
Sure.
Tom, I think the use of these forms is great, and having things organized like this obviously would make things easier for anybody. Because we do it differently up here, and we're more generally assigned for a block of time to fill in for a sitting judge, the only way that these forms are going to be used in the cases up north is for the sitting judges to be the ones to require it or encourage it. And so something like the order that Judge Hoskins is working on might be, hopefully will be shared with the judges up here, because I think the sitting judges up here in the second would also benefit from that.
I think they'd appreciate it.
Yeah,
It's a
Judge,
good approach.
can you share that with Judge Robb, maybe when you get far enough down the road?
I can do anything for a price, so it's all. I'm happy.
We'll show you a good time.
Yeah. As soon as I get that done, I'll send it up, and she'll edit it and send it back with a few red marks, and it'll be good.
And we had all the second.
Every one of her suggestions will be worthwhile.
All of them were there.
Yeah.
They were all there. More questions? I think that at the next Ely conference, you need to do this again, only because we'll have new attorneys from the February bar and from the July bar. And by that time, some of them will be practicing family law, and I guess we need to have nothing like a refresher course. For
Let me speak to all of you about that. This is much more maybe for the sitting judges. The reason that Ely was a little bit different this year, I believe, is because my partner, Jason Enemy, went on to the executive council for the Family Law Division and volunteered to help with setting up the types of CLE that we would have at the conference. He and I have been talking about this for quite a while. I have this philosophy that I believe what happened over the years was that people that were very influenced by the Nevada trial lawyers, now the NJA, and the way they set up their conferences, tried to duplicate that approach in family law. And that approach is, in plaintiff's trial work, it's very easy to bring in experts that do jury selection and argument, and they're brilliant and they're great and they speak, and it's a great CLE. You can't really do that in family law. When you bring in out-of-state experts, and especially this time it was embarrassingly obvious that some of them hadn't even bothered to check whether Nevada does it this way or that way. And the main thing being that the rank and file in that room it's a younger attorney crowd. They don't have a lot of experience, and I have found the reaction to nuts and bolts stuff like this afterwards is huge. And the reaction to a bunch of, people pontificating about the theory of whatever is they sit through it, they sleep through it, but they don't care. And
They're reading the
so I always try to go to the very lowest level and the highest level, and believe me, it doesn't matter how much experience you have, you learn something no matter how simple the subject is, even if you think you know it inside out. So yes, we are trying to make it more practical. How do you do this type of thing? And that was the whole approach this year, was preparing for trial, opening argument, closing argument, presentation of evidence at trial was what Judge Hoskins spoke on, and all the way through. There were some out-of-state people, and I think they were the weakness in the schedule, and I talked to Jason about that. So if you talk to lawyers and you get a feeling for that, please let us know what your feedback is, because I hear the bar basically wanting to know how to do things, not about theory and other things. And particularly, we had an alimony presentation a few years ago. I guess I shouldn't name any names. But the example that they used for their alimony presentation was a surgeon who made $1.2 million a year. And I was sitting there, and I could just see the room just turn off. They tuned out, because nobody has cases like that. Some of us might have gotten a chance to work on some of them or do more of them, but it's useless. I did a lecture on valuation for dummies, which was really, not because I'm good, it was just, let me tell you what valuation is, because we had valuation after valuation, business valuation lectures in Ely, and I couldn't listen to them. And I live and breathe and eat that stuff. I've done so many cases. They were horrible. And we had great experts. They just weren't interesting. So I just told them, this is what it is. And they're like, oh, my God, that's simple. And then I said, okay, and now I'm addressing what you do when you don't have any money, but you still have a business. And we did it that way, and that was a huge response, because people learned how to do. So this is learning how to do and how you might want to do it if you're already experienced and so forth. So we're going to try to do that. So if you get attorneys talking or you get feedback, tell us, or encourage the attorneys to encourage the family law section to do that, because that's what's going to benefit the bar. The experience out there, the training. I went into business court, 2 or 3 years ago. I've not been in the courthouse other than for family lawyers, stuff downtown, in I don't know how many years, and it was remarkable, the quality of practice in business court, because it's all the big firms who train their young lawyers. And the difference is remarkable. And yes, they do select very bright people to work in those big firms. I understand that. But how many lawyers do you have up here in front of you? I talk to my associates about this all the time, that are very bright and they just aren't effective. They have no idea what they're doing. So again, this is all part of what we're all trying to focus on, if only to keep your sanity, and make you want to be on the bench because we need you so badly. So that's why I'm saying this, is that you're a very important group. You have no idea how important, how much we appreciate you, which I said before. But if you can get feedback on this, it will start to happen because they are listening, and the Supreme Court, I can tell you, is very interested in this.
Well, one of the things we run into, all my former partners, Plessis and Bayless and Cook, are all on the disciplinary committee, and they're seeing a lot of complaints against young lawyers, and a lot of them involve family law. And that's because not returning phone calls and then taking money and then not doing the work. And so we've got to save our own, to tell you the truth, because my colleagues are real tough on discipline. My God. I mean, you see all the dissents that are filed when they recommend years of suspension to people. So I'm hoping Tom does put this on again in the February thing. And if you ever gone to Ely, it's a sellout crowd. I feel like Methuselah when I go. I feel like I'm the oldest person in Ely, let alone in the Bristol Convention Center. But you got a lot of young people. And, we've got to bootstrap them into being Tom Standish and Bob Dickerson and the rest of the superstars in family court. And it really is a shame that we don't have the mentorship that we used to have.
Ely is huge. It's the biggest. It's bigger than the State Bar, and every year it's the same. It's packed. They had 360-some lawyers.
And we had the judges up there Wednesday afternoon and Thursday morning, and then we joined the lawyers for Thursday afternoon and Friday. And it's an eye-opening experience. We had the rule judges, Jack, and they come. We get a nice turnout from the rule judges who do everything. I mean, they're real handy players.
That's why none of you win.
Chuck, anything else that you can say? Let's open it up to Chuck. I'll criticize Chuck a little bit about her. Eileen. Let's go after Eileen for a little bit. First, let's go after Gloria, who was originally the presiding judge. Anything that you want to help Chuck out with, or Chuck can help you out with? I know he's going to do this order, and we're going to make sure you get some briefs when you go for the settlement conferences.
Yeah, I think it's going to be great if they're going to be attached to the briefs, because then you'll get all the information about how long they've been married and how many kids they have and what their income is, and then you can match it up with the figures here and kind of put the whole picture together pretty easily.
For those primarily pro-pers that do not do these, you might do a little training session for the law clerks.
Yeah. The ultimate plan is this will be attached to their case management order, to their referral to the senior judge program. This requirement is, it has to be in this many days ahead of time, but there is a big part of that. The law clerks for the departments need to be following up ahead of time so you guys aren't wasting your time.
I'm doing a calendar next week that I know that the pro-pers don't have anything even close to it. Now, they may not even have FDFs, but, it's...
But I'm not going to refuse to do a settlement conference if I've done settlement conferences where I had no prior information except what I pulled out of reading the motions that have been filed.
Yeah.
And I've still gotten settlements. Sometimes it's just a matter of getting the parties to sit down and talk, especially if they're
Just sitting in the room.
Just sit in the room.
Yep.
Even with attorneys, sometimes.
Yeah, no, it's the Judge Ritchie thing of you just make them come and
Just
something
make 'em
good
come and
happens.
sit down.
Yes.
It would be helpful if you had a training, and probably a little bit longer training, with the self-help center. So someone's going to come in, you're going to sit down, and you're going to help them fill out this form. Or tell them, here, we're going to help you fill out the FDF, and then you take from the FDF, and this is where you put it into the form, or things like that. Because that's where a lot of the people are going to go and ask those questions.
There's also so many of them who have so little time. The self-help center has so little time to spend with them. It's just the volume is...
Right, per person.
Right.
How much help do we get from pro bono lawyers in just regular divorce cases? I know we get a lot of help in abuse, neglect.
Quite a bit.
And how do they come into the cases? Through legal aid?
Legal aid.
I just heard today from Sarah, because I referred a pro-per to legal aid. And Sarah, your law clerk, Chuck, said there's such a backlog at legal aid that it's difficult. But
They'll tell them, expect at least 60 days at the earliest from when you request to when you get in, and sometimes there's hearings set in between there, and so It's just, and it throws off our time frame. We've made representations, we're going to try and get the custody done in 6 months and the trial done in a year, and if it takes them 3 months to get an attorney, then usually they don't think about that till after their answer should have been filed. It just...
That's not fair to the kids.
No, it's
Well,
not.
and they
deserve a decision.
prioritize, too, about, are there, after they've gone through the screening, is this a case with domestic violence? Is this a case that has immigration consequences? And so the person who is just looking for some help and doesn't have one of these hot issues, they're going to be backed up. It might take them 6 months to get an attorney.
What we do, our family law bar, I think we had, last year when we did the thing that Mike Douglas was doing with the One campaign, the family law bar had more pro bono volunteers than any other type combined. There's that much need, and there's that much of the bar that's participating, so.
Our pro bono program for appeals worked out. In fact, they have a waiting list of attorneys who want to do pro bono appeals, because now we have that appellate section of the state bar with a bunch of young attorneys.
They all want to
And
argue
we guarantee
in your
them,
face.
we guarantee an oral argument, and they love it. And they've come before us, and they've been dynamite. They have been great. And sometimes it's pro bono on both sides, and they're just excellent. And it's very impressive, very impressive. And the Court of Appeals is going to continue that on with the pro bono appeals with the right to oral argument. But anything we can do to help you, Chuck, because I know that
Well, and if anybody's got any suggestions,
the
my
same thing
staff
goes
really
with
tries to...
Bridget Robb, and the same thing goes with the rules. If you can help the rules out at all, I'm sure that's what we're here for. I know once in a while I get a call to fill in for some of the judges in the rural areas.
What do you guys up north, what do you find most frustrating as a senior judge?
It's completely in your discretion.
I mean, anything, or?
Like what?
Well, down here, one of the reasons why we do so many settlement conferences is because the sitting judges don't have the time to do them. And really sit and do what you're talking about, Deborah, because that's what we do. We sit and we talk, and we do get a lot of cases settled. And then we sit for the sitting judges. But some of our frustration is, yes, the high number of pro pers, sometimes the inconsistency between departments in terms of whether they follow the rules, inconsistency in law clerks, and then not, when we have settlement conferences, not having enough information in advance because they haven't complied with the order to give us the information we need. So those are just a few of what we've been encountering down here. So I was just wondering, what issues you guys might have.
Well, that inconsistency among departments and law clerks is, if you let that bother you, you'll have been bothered from the first day you sat on the court to the day you die, because it's always going to be, you have to roll with stuff like that. I think, personally, it's been a little while since I've been in the family court, but whenever I go to family court, I always find the staff to be the most delightful aspect of it, and pro per parties to be the biggest challenge, because they often don't really understand the importance of the information that they might possess. Sometimes candor is an issue. But pro pers are a challenge, and that will always be too. So I think that's just one more thing that isn't really going to change, although whatever help, I think the self-help centers over the years, Scott could speak to it because he remembers in the days when there weren't such a thing. And I certainly remember the days when everybody who needed a divorce had a lawyer. But those days are so long gone. 70% pro per participation is pretty much what Washoe County has. I can't speak for Carson, but I think the pro pers present a lot of challenges. I think these forms are going to be very helpful. It means I'm going to have to learn how to use Excel.
Anything else, Tom?
Nope, that's it.
Well, I want to thank everybody for, I hope this will help in settlement and in trial for all my senior judges. Keep up the good work.
I want to thank Tom and Chuck. I think that's a really good presentation.
And again,
Thanks, you guys. That was good.
Thank you very much.
Get hold of Tom if you have any questions. They'll be glad to answer.
Yep, anytime.
Bye, everybody.
Bye.
March.
I hear you.